Welcome to our webinar. We are looking forward to talking about spousal limited access trusts. This has nothing to do with the limitations of your spouse, which I'm sure we could talk about that too later on if you like. And that's what we end up doing sometimes when we talk with clients. We talk about the limitations of their spouses. But believe me, your spouse thinks you have worse limitations. And slattery will get you everywhere, so just be nice to your spouse, at least today. But I'm here with one of my favorite people, Christopher Denicolo. Chris has been a partner in our law firm for a long time, demonstrating how incredibly tolerant he is. And he also has a near photographic memory. So what we're going to talk about is Chris's topic for the Notre Dame Tax Institute. And everyone here, I hope, will sign up for the Notre Dame Tax Institute so that you can attend SLATs, how to keep your SLATs from going kersplat. And that's going to be a 2-hour presentation on Wednesday, October 20. And if you sign up for the Notre Dame Institute, you're not only supporting a wonderful school, a great university, but you're also getting a lot of great programming. And I'll be talking on Friday, the 22nd, with Jonathan Blottmacher on certain ethical issues and strategies to keep things out of litigation. So thank you for that advertisement. And let's go forward here. Chris, before we go forward, I just want to mention, because we have people on this webinar who probably don't know what a SLAT is. So a SLAT is a trust where a married couple, one spouse takes that spouse's assets. I'm going to call that spouse one. That's an affectionate term. Spouse one takes assets belonging to spouse one and gives them to the trustee of a trust. The trust says that the trust is for the primary benefit of spouse two. Spouse two can get what spouse two wants or needs for health, education, maintenance, and support. If approved by the trustee, spouse two may be the trustee. Now, what neat things have happened? Number one, spouse one has gotten assets out of her estate, not subject to estate tax. Number two, these assets are not in spouse two's estate because spouse two did not fund the trust and is limited to what is needed for health, education, and maintenance of spouse two. Number three, creditors of spouse one cannot reach into the trust because spouse one's not a beneficiary. And creditors of spouse two can't reach into the trust because under the Uniform Trust Code, if someone else gifts to a trust and you're limited to what you need for health, education, maintenance, and support, the vast majority of creditors can't reach into it. So that is a SLAT. So Chris, question one, while the donor spouse is living, can assets gifted to a SLAT be exchanged for different assets?
That's a great question. And most SLATs we draft, in fact, virtually all SLATs that we draft are what's known as grantor trusts for federal income tax purposes. And what that really means is that spouse one sets up the trust and has certain powers with respect to the trust, and any income of the trust or deductions of the trust pass through onto spouse one's income tax return. One of the powers that we commonly use is what we call a swap power, where spouse one would have the power to exchange assets in the trust for other assets of equal value. Very common. So the short answer is yes. And by reason of this swap power that we have, it can be a great planning technique to have that and utilize it in the future.
Question number two. If the majority of your assets are in investment accounts with your spouse as joint ownership, is the SLAT an option? And if so, what steps do you need to take to set up individual accounts if you need them?
Okay, so Alan, you and I think take a pretty conservative position here just because of what's at stake. The way we view this is that if spouse one and spouse two own assets jointly, we usually have those joint assets split so that spouse one has her assets and spouse two has his assets. We don't want spouse two's assets to go in the trust because if that happens, there could be catastrophic estate tax and creditor protection implications. So what we like to do is just have the assets split and have spouse one use her assets to fund the trust. If, for example, you want all joint assets to go in, one technique we've used is we've had spouse one buy the assets under an arm's length transaction with documented fair market value. That way, there's no argument from the IRS that, wait a minute, spouse two's assets went into this trust of which spouse two is a beneficiary. Because if that's the case, you're going to have estate tax inclusion in spouse two's estate. We don't want that at all.
Okay. So Chris, going to your slides now, how would you like to cover these?
Yeah, I think we could just go through, Alan, and mention some things that are important, starting with the basics, of course. One of the big things, of course, that comes with a SLAT is that it's for the benefit of another spouse. It wouldn't be a SLAT by definition otherwise. So we typically provide that spouse one sets up a trust for spouse two. Spouse two can be a beneficiary, as you mentioned, for what's needed for health, education, maintenance, and support. Spouse two can be a trustee of the trust, can be the only trustee, can be a co-trustee. We typically restrict trustee powers for distribution only to that health, education, maintenance, and support standard. I would be cautioned to not have sole discretion, because if spouse two is trustee and can distribute assets to himself for sole discretion, then you may not have the estate tax savings. We also like to provide for flexibility by giving spouse two a power of appointment over the trust assets. The term power of appointment is a fancy way of saying it's the right of someone to do whatever they want with the property. And we typically provide that spouse two has something known as a limited power of appointment, which is really a power that can be exercisable anywhere except to spouse two's estate, spouse two's creditors, or the creditors of spouse two's estate. And the reason that's important is because if the power is not limited, if it's something called a general power of appointment, then there will be estate tax inclusion in spouse two's estate. So we don't want that. Another neat little thing about the SLAT here is that you can put in all sorts of restrictions on distributions. You can put in a host of provisions relating to what happens if and when the spouses divorce. And this is something we'll get into in a little more detail. But Alan, as we've done more of these, I think we recognize that there's some risks going in as the planner. You have to let the spouses know, even if it's all sunshine and rainbows right now in their marriage, down the road there could be a divorce. And what would happen on a divorce? Who pays the income tax of the trust? Who's entitled to change the trusteeship of the trust? So those are all questions that we can get into. One big item that we've also taken a conservative viewpoint on is something called the reciprocal trust doctrine. And we have clients that say, well, a SLAT sounds great. I'll do one for my wife and she'll do one for me. And the answer to that is, well, that's not really a great thing, because something called the reciprocal trust doctrine that's come down through case law, the IRS has interpreted such a situation to basically uncross the trusts. So I would set up the trust for myself, my spouse sets up the trust for herself, and we don't get any estate tax benefits, at least in Florida, and the creditor protection benefits are also low. And we're very worried about that. Just like we're worried about spouse two being a contributor to the trust, we don't want to play around. We'd rather have one spouse fund a SLAT for the other, and then the other spouse can fund the trust for descendants or no trust at all. But that's a very important point. As we mentioned earlier, the trust is almost always disregarded for income tax purposes, so spouse one pays the income tax on the trust. That's a nice little planning technique because spouse one can engage in transactions with the trust, selling assets to the trust in exchange for a promissory note or for cash or whatever. In any event, if it's a grantor trust, there's no income tax. There's no gain recognized. So as estate planners, we can use that loophole in the income tax code to have fantastic estate tax planning results.
Okay, so I'd like to go back through these 5 points and just mention a couple things about each point. A lot of times we are using a Nevada trust, and we're using a Nevada trust so that the settlor could become a beneficiary of that trust if some bad things happen. Our thinking is we prefer Nevada because the lower cost trust companies are there that we're familiar with, and we've been using Nevada as a jurisdiction for a number of years. If I set up a trust for Marcia and I put a couple $1 million in there, which were the profits I made from Chris's part of our legal practice. And then Marcia, to the surprise of everyone, divorces me. I might want to be a beneficiary of that trust again. So that trust can have a provision which says that in the highly unlikely event of divorce, and by the way, lawyers, we always use those words, highly unlikely event of divorce, whether it's highly unlikely or not. In the highly unlikely event of divorce, the SLAT will divide into two separate trusts. A Marcia trust, which will continue for Marcia's health, education, and maintenance without influence from Alan, and a descendants trust for the descendants of Alan and Marcia, where the trustee will be chosen by Alan, changeable by Alan to anyone who's not related or subordinate to Alan, and with trust protectors who could add Alan back to the trust as a beneficiary if my net worth ever goes below a relatively small amount. So even under Florida law, if Florida law were to apply to this trust in a creditor situation, I don't think my creditors can reach into the trust because I'm not a beneficiary and there are not circumstances existing that would cause me to be a beneficiary. Now, if Marcia is a trustee of the trust, then the trust has to be disregarded for income tax purposes. There's no two ways around that. And she would be co-trustee with a Nevada trust company. Item 2, a lot of law firms draft these trusts to say, not only can Marcia get what she needs for health, education, maintenance, and support, but she could get everything in the trust if our good friend, Chris, who we've appointed as the independent trustee, gives her permission to do that. I am not crazy about that type of provision because most of my clients do not want more than what they need for health, education, and maintenance. And if and when they break their hip at age 80 and have an aggressive in-law or friend involved or a remarriage, I don't know that I want to make it easy to take more out than is needed for health, education, and maintenance. But let me mention, and this may sound very interesting, when you have a Nevada trust that provides for health, education, maintenance, and support, you can change the trust or decant it, pour it into a new trust that has a discretionary power to give the same beneficiary more than needed for health, education, and maintenance if certain requirements are met. You have to jump through some hoops unless your trust says, I absolutely don't want that. So that's this brief discussion of number 2. Now, number 3, the beneficiary of an outright disposition or general power of appointment marital trust. In other words, if I think I'm putting 11.7 million worth of assets in there, but I accidentally put 13.7 million, I've made a $2 million accidental gift to the trust, there will be an overflow to a trust that will qualify for the marital deduction. Number 4, the US v. Grace US Supreme Court case, which allowed reciprocal trusts where they said, well, they're different enough. They're really both for the benefit of each other, but they're different enough. The Supreme Court did not consider that the reciprocal trust doctrine also applies in the creditor world. That if I set up a trust for Marcia's health, education, and maintenance, and she sets up a trust for my benefit, even though the trusts are different, a creditor can uncross them. Mm-hmm. And since a creditor can uncross them, the estate tax exempt happens. Because if I can throw a big party and not pay the bill and have it paid from the trust I set up for Marcia because of the reciprocal trust doctrine for creditors, then that's going to be included in my estate for estate tax purposes. And because I live in Florida, I can't be sure that the Nevada creditor protection law is going to work. So that's why we are not comfortable with reciprocal trusts. And, you know, someday the IRS may find out about this creditor issue. They certainly won't find out about it from me because nobody here, they don't listen to me. But they may find out about it, and then they may say, sorry, we were wrong allowing all these. We don't allow them anymore. So that's our concern. So at least have a trust protector who can strip away rights more than 3 years before the person dies. And secondly, as Chris said, most of our clients are wealthy enough. If you're wealthy enough to do a SLAT, do you really need the other trust to be for your benefit? You could borrow from it. You could, you know, it can give your children assets, and then they could give you assets. So we just don't see the need.
Alan, quick question. Hundreds of slats that we've set up, how many can off the top of your head you recall where the spouse is actually taking the distribution from the slat?
I recall zero.
Yeah, I can't think of.
Clients who set these up have the money. They don't need it, or they sell assets to it in exchange for money. So no, you're right. And we have set up literally hundreds and have not had, you know, anyone need to take any assets out unless it was by mistake or by reason of an installment sale. All right, Chris, page 13.
Absolutely. So a few more things here that we consider when we set up slats or when we discuss slats with clients. One is the funding of the trust. Now, the big hoopla these days is, well, this $11 million plus exemption is going to go away. It's going to go away in 2026 as the law currently stands. It may go away sooner than that. And many clients want to use their exemption before it goes away. A great question that we've gotten, in fact, I got a good one yesterday from a client. Can I split the gift with my spouse? And what that means is that if I set up a SLAT for my wife, Sophia, and I put $4 million of assets in the trust, if I didn't do anything split gift wise, I would use $4 million of my exclusion when I fund that trust. But under the split gift rules, it might be possible to cause the gift as having been made $2 million by me and $2 million by Sophia, only for the purposes of use of exemption. So she would use $2 million, I would use $2 million. There's a little bit of a nuanced area where the spouse is a beneficiary of the recipient trust. So if Sophia and I put $4 million into a trust for descendants, it's really well settled that we can split that as if it's $2 million from each of us. If she's a beneficiary of the SLAT that receives $4 million and we desire to split the gift, well, it really is available only if her interest is severable and ascertainable, which has been found to include a health, education, maintenance, and support right under something known as the Robertson case from the 1950s.
So we're talking about splitting the gift. So if I put $10 million worth of assets into a SLAT, I think they're worth 10. The IRS thinks they're worth 15. The IRS says you owe a gift tax, and we don't believe that your overflow marital deduction works. Well, then Marcia could split the gift with me. We would consider the gift to be a $7.5 million gift from each of us. So there would not be a gift tax owed. And in order for that to work, it needs to be highly unlikely that Marcia would ever benefit from the trust, even though it's a SLAT for her. So sometimes when we do a large controversial gift like that, we'll do 2/3 of it from the wealthy spouse to a SLAT, and maybe 1/3 or half to a descendants trust, thinking that there's plenty in the SLAT to support the surviving spouse or the spouse, and that there may be a gift split. So that's the way that works. Kelsey, should you call Chris on his cell phone and see if you can help him out?
I'll go ahead and do that. Thank you.
Okay. So number 8, should the surviving spouse be given a limited power of appointment to direct how the trust assets will pass? Well, the answer to that is almost always yes. But there's really 2 types of SLATs that we do when you think about it. The first kind of SLAT is for happy marriage with all marital assets. In other words, Marcia and I started with nothing. Now we've got assets, and I'm going to put my half of those assets into a SLAT for her. And if Marcia predeceases me, how would she feel about me getting benefits out of that SLAT by having a provision that says that while it can't benefit me, it could benefit a subsequent spouse of mine during my lifetime on a conservative standard? And we call that a floating spouse provision. And she may not want that. I haven't had the conversation. I have the draft trust, but I haven't brought it home yet. Now, on the other hand, if this is my separate property, if this was my second marriage and I went into the marriage with a lot of assets, we've got a prenuptial agreement, these are really my assets, I put them in the SLAT, then I definitely want to have a floating spouse provision. So that would be the other type of SLAT. So the SLAT that I would do for Marcia with a long good marriage is that she would have the power to appoint the assets of the SLAT to our descendants, and maybe even to any charity. And I would certainly trust her to decide which of our descendants should inherit and which wouldn't. On the other hand, if this is a second marriage, or maybe we have a descendant who's pushy and unruly, then Marcia's power of appointment over these assets at the time of her death are going to be limited. Maybe they don't exist, or maybe they can only be exercised with the approval of my descendants. That's going to be an art, definitely not a science. But I can also give Marcia the power to appoint the assets to a trust to benefit me on her death. So it says my spouse will have the power to direct the trust assets to descendants of our marriage or to one or more charities that we've supported before the funding of this trust, because I don't want her to have to give it to a charity that might take advantage of her, or to descendants of my parents in trust or outright. And as long as there's no pre-existing understanding between us, she would be able to exercise that power of appointment in a way that it could then pass for my benefit if we decide we want that to have happen. And she would do that by putting a provision under her last will and testament to that effect. So we have a SLAT checklist here. Number one, is the client the grantor or both spouses? In other words, if I'm representing only the grantor, then am I going to draft this so that if there's a divorce, the spouse gets nothing? I mean, that's not what my SLAT would say with Marcia, but if this was a second marriage and these were all my assets, I would want the SLAT to say in the event of a divorce, the spouse gets nothing and everything's for my children. Will there be a floating spouse provision? As we said before, if Marcia passes away and I remarry and I need assets from the SLAT, the only way to get them safely will be to get them through paying the living expenses of my next spouse. So that's the floating spouse. It has nothing to do with a swimsuit or whether they can float or anything like that. So another provision we very commonly put in these trusts is that if I remarry, in order for even me to get a benefit or for my spouse to get a benefit, the spouse would have to sign a prenuptial or postnuptial agreement agreeing not to pursue the trust for any purpose, for support, alimony, for asset division, or to see the trust as a source of assets to pay alimony or a reason not to receive alimony. So that commonly is in the trust. Now, F, under the grantor trust rules, this trust that I set up for Marcia and our descendants, I am treated as the owner of the trust assets, and the income goes on my Form 1040 income tax return as long as Marcia is trustee, for sure. Now, if Marcia resigns as trustee and I do not have the power to trade trust assets for assets of equal value, and it takes an adverse party to approve a distribution to Marcia, then there's a chance that the trust will be taxed at its own bracket. This can be a controversial area. because typically when we set this type of trust up, we want the clients to pay the income tax on the trust income, because that saves estate tax, because the trust can grow tax-free. But then a certain point later, the client may come back to us and say, okay, that trust is worth plenty. I'm not worth enough. Make that trust pay its own taxes. And if your spouse has been a beneficiary of that trust, you may not be able to reverse out that grantor trust status unless, number one, there are one or more beneficiaries of the trust other than your spouse who have to approve any distribution to the spouse. And even then, you may not be able to get out of grantor trust status because there was an Internal Revenue Code section, 682, which said if you set up a grantor trust and get divorced, it's not a grantor trust anymore. And they repealed that provision, probably by accident. They didn't realize what they were doing. So now we're hoping that they'll have a technical correction. But what some clients have done is actually signed a postnuptial agreement where Marcia would sign a postnuptial agreement. By the way, Marcia would never sign a postnuptial agreement. Marcia would sign a postnuptial agreement that says, if we get to, in the highly unlikely event that we get divorced, and Alan has to pay the income taxes on this trust, no matter what, then I will reimburse Alan for those income taxes. And so that's something that just needs to be thought about, or by you advisors who are advising clients with this situation. Otherwise, that SLAT may need to put its assets into a C corporation or somehow otherwise block the income. Chris, any comments on that?
No, the only thing I want to mention, Alan, is with this, the Internal Revenue Code 682 issue, as we call it, there's some slides later on where we have language regarding the marital agreement. So if it's something that an attendee is interested in, I recommend you take a look at that in this deck.
Okay. All right, so I actually have a polling question here. Those of you CPAs love polling questions. Which is true? SLAT means spousal limited access trust. It is defective for income tax purposes if the spouse is the trustee. It's also defective for income tax purposes unless an adverse party must approve distributions to the spouse. And D, all of the above. And the answer is D, all of the above. So, Chris, we've probably covered a lot of this stuff. Where would you like to go? Now, for those lawyers out there, we have given you some sample language, some disclosure provisions, and things like that that you can use in your SLATs. Let's review here. Polling question 2, advantages of a SLAT include A, not subject to estate tax, B, creditor proof, C, can benefit the spouse and descendants, and D, all of the above. Then we've got a floating spouse provision for you at page 43. Maybe go get in the hot tub and float together and decide if you want the floating spouse provision. We've got language about the 682. And then we've got a lot of information on gift splitting, which I don't think we need to cover because it's so technical. But the advisors out there can go through that. Now, page 52, we have a graphic, and we can show you what a SLAT looks like and how we would typically use a SLAT. And we've used this before, but we'll use it again. So you've got your client and your client's spouse, and they jointly own a LLC worth $20 million. And you've hopefully gotten a valuation report on the assets in the LLC, and you've confirmed it's worth $20 million. And your client sets up a spousal limited access trust. So this circle should say client spousal beneficiary trust. You put a small seed capital gift under the trust, maybe a $700,000 gift to the trust. And then you take your 49.5% non-voting member interest in the LLC. So the LLC is owned on day one, 1% voting, so that 1% gives control, 99% non-voting, which gives no control but the right to 99% of distributions. You transfer 49.5% non-voting to your client, 49.5% non-voting to your client's spouse, and now your client has taken $700,000 and made a gift to this trust and sells the 49.5% non-voting member interest, which is valued by a valuation expert at $6,930,000. The note bears interest at approximately 1.98% if you do it this month. And what have you done here? Well, you've shifted about $3 million worth of value to a trust that will be held for the health, education, maintenance of your spouse and descendants, will never be subject to estate tax. You will pay the income tax on the income of the LLC, and you'll only receive about 2% of $6.9 million a year. This chart was made when the applicable federal rate was 1.35. It's now about 1.98. So you're going to get not that much a year, and the assets will hopefully grow in value. Now your spouse will set up a trust for descendants, and that will be for descendants only, so we don't have to worry about the reciprocal trust doctrine. So what happens in 10 years? In 10 years, the assets have grown at an average rate of 7.2%. They have doubled in value. The SLAT is worth approximately 20 million, about half of 40 million. It's used at 700,000 to make payments on the promissory note, and it still has some left. So the SLAT is now worth about $13 million, and you haven't made any gifts to it. That's pretty darn good. The couple themselves have moved about $26 million out of their estate. So if you're wealthy and you're watching, the two W's, you're wealthy and you're watching, we want your assets under LLCs discounted, sold to irrevocable trusts in exchange for notes, so that we've locked in a discount before Congress takes those discounts away. We've locked in a low interest promissory note before Congress takes low interest promissory notes away. We've put you in a trust that's disregarded for income tax purposes so that you can pay the income tax before Congress takes that away. And a lot of it is in a SLAT. So if you need what you gave away, that SLAT can pay half of the living expenses for your spouse, extraordinary expenses for your spouse, and also for your next spouse if it's got a floating provision. If these are in Nevada and you run into hard times, your net worth goes down below, say, 2 million, and you have a much higher net worth than that, then you may be added as a beneficiary of these trusts. So this is really where the SLAT normally fits in with the estate tax. Yeah, it's work to set up the LLC. You may have one or more LLCs to get the LLC funded with assets, usually about 30 days before the sale. Then to come up with a value for the non-voting interest in the LLC, to have a SLAT that's been properly drafted, to have the trustees sign the SLAT, to get all this done. That's what I would try to get done before the end of this year. Why? The Bernie Sanders bill said that if you do all this before the bill passed, everything would be grandfathered. If you did it after the bill passed, not so much, and your exemption would be limited. Now, if you do this, you're using very little of your exemption. But then if you see the Senate fall to Democrats in 2022, you could forgive the note to make the use of your exemption. Otherwise, there's a reason to keep the note in place. One, you might need it someday, but two, If you die owning a note that only pays 1.98% interest only for 20 years, then that note is not worth 6.9 million on your estate tax return. It may be discounted by 20% or more. Chris, anything to add?
Yeah, one thing also with the note, and as you said, Alan, principal payments can be made if and when it's needed at some point. You know, some clients like to receive early payments of principal to maybe pay other living expenses or to pay income taxes, which, you know, again, having that note in place does allow the grantor spouse with a way to receive assets indirectly from the SLAT, again, at arm's length, which is really important to assure the estate tax benefits will occur.
Right, right. Okay. So here's just looking at it a different way. And quite often we put a separate third trust in place, which has the right to control if and when there will be liquidations or distributions from the LLC, in order to take into account something called the Powell decision, taxpayer versus Powell, I believe it was called, in Internal Revenue Code section 2036A2. I won't get into what that means, but you should ask your advisor whether you should have this type of structure, having somebody completely separate and apart from the rest of this control if and when the LLC can make a liquidation or distribution. Another polling question. SLAT features can include A, dividing the trust in half with separated control on divorce. B, the grantor can become a beneficiary in an asset protection trust SLAT. C, the spouse can have a limited power to appoint trust assets to direct where trust assets go on the spouse's death. Or D, the correct answer, all of the above. There's no need for you to answer these. We just find that CPAs like to see these in these types of presentations, and they can be used later when we do this for continuing education credit. So Chris, what's next?
Well, what we're skimming through now is a letter to clients and also an article that we've written for the Bloomberg VNA Estates, Gifts, and Trust Journal, both of which are attached here as separate attachments. But the cover letter that we have explains the SLAT mechanism and how to set it up and really the different considerations in layman's terms on a way that clients can understand. A lot of the material in the letter, of course, we've covered organically to this point. One of the items mentioned in the letter, which I think is important, involves the funding of the SLAT. And when we fund the SLAT, as Alan showed on that slide earlier, we're typically assigning non-voting interests in an LLC. Well, reasonable minds certainly can differ as to the value of a non-voting interest in an LLC. In fact, there's a whole body of case law with the IRS, whereby taxpayers and the IRS are fighting over what discounts should apply and what values should apply. One way to get a little more certainty as to the value of assets that has been transferred to the trust is to use something known as a WANDRY, W-A-N-D-R-Y style assignment, which is based upon a court case, a tax court case from about, say, 10 years ago now, where the assignment says, I hereby transfer to the SLAT a non-voting interest in the LLC that's worth $5 million. What you're doing there is you're specifying the value that's being transferred, and certainly you take the.
Oops. I apologize for the sound problem, but he seems animated and that he knows what's going on.
Looks like cut out there for a second.
Now you're back.
Okay, sorry. So what I was saying is that the WANDRY style assignment defines the value of what's being transferred to the trust. So instead of saying a 49.5% non-voting interest in the LLC, we instead say a non-voting interest in the LLC worth $5 million is transferred to the SLAT. And by doing it that way, if the IRS challenges it, you can point to the assignment paperwork that says, well, we always intended to transfer only a $5 million amount. So anything over that is to pass back to me because it was never transferred. That's a very important technique used when funding slats. We have a number of slides later in the presentation which address the Wandry style assignment and alternative viewpoints for doing these types of assignments, one of which involves an overflow to charity, where you can say, I transfer X units in the LLC, and if the value is in excess of a certain specified amount, the overflow would then pass to a charitable trust, to which the charitable gift tax deduction would apply, so no additional exemption would be used.
Should we talk about giving your father-in-law a general power of appointment?
I think that's a great idea. So earlier I mentioned that general powers of appointment are powers of appointment where someone has the power to basically control the disposition of assets to themselves, to their creditors, to the creditors of their estate, and to their estate. And if a person holds that power under Internal Revenue Code section 2041, the assets are going to be includable in the estate of the power holder, which doesn't sound that great initially. But with these huge exemption levels of $11 million plus, far cry from the $600,000 or so in the late 90s and early 2000s that applied, sometimes we want to invite inclusion. So if we have a SLAT that I set up for my wife, Sophia, and I include her father, Paul, as a beneficiary of the trust, we can receive income as the trustees determined appropriate for health, education, maintenance, and support. And he also has the power to appoint assets to the creditors of his estate on death. When he dies, the assets subject to the general power of appointment are included in his estate. Therefore, they get a new basis under Internal Revenue Code section 1014. So the low basis assets I put in the SLAT can now get a high basis because they were included in Paul's estate, and the assets then can be held in trust for my spouse and descendants with a brand new basis and can save income taxes if and when they're later sold. That is a really nice wrinkle that we've been implementing, especially at the $11 million exemption levels, where clients have relatives and trusted elderly friends that could be given this power of appointment. And the power of appointment can be subject to approval by one or more independent parties, such as Allen or a trust company or a CPA, so that any misuse of the power is unlikely or impossible. But it's a really nice income tax planning tool.
So in other words, if I set up this SLAT for Marcia and her parents are living, I could give each of them a right to receive distributions in the discretion of the trustee if it's ever needed for them. And I could give each of them the power to direct the trust assets to creditors of their estate with permission of my best friend. So they really don't have the power, but under the regulations of Code Section 2014, they do have the power. And then one of them dies and we're very sad, and we get a step up of income tax basis of all assets in the trust and can sell them without capital gains tax and begin taking depreciation again on buildings that we use. That is not bad.
Not at all.
And that's called the OBIT. Ed Morrow has made it famous. And what does OBIT stand for? I forgot.
Optimal Basis Increase Trust.
That's right. That's
spot
right. On. Yeah, exactly. Now, and we have some sample language here. Now, this language on page 94 is greatly oversimplified. So if you're a practicing lawyer or a practicing CPA and you'd like a sample form that's not so simplified, I'll send it to you. I'm not going to send it to laymen because, quite honestly, you could hurt yourself if you try this at home. What about eliminating discounts, Chris? We should just mention that since we're on.
Absolutely. So the discount is great for estate tax planning purposes, but in our situation where we have maybe a relative with low assets, high exemption, we want to invite estate tax inclusion. Perhaps we want to give the trustee of the trust the ability to basically sell the interest for fair market value without regard to discounts for pro rata asset value. And by doing so, we take the position that discounts shouldn't apply, or at least should be very low, which therefore increases the amount of the basis step up. because discounts are indeed a double-edged sword. You get the benefit of a lower fair market value on contribution to the trust, but if you give someone a general power of appointment over trust assets, the basis step-up is going to apply only up to the discounted value, because by definition, the discounted value is fair market value. Now, if, say, the trustee of the trust had the ability to liquidate the ownership interest in the LLC for the pro rata percentage of the assets, then maybe the discounts would be.
So let me go back here now. Page 95. This is in all of our slats, and clients don't necessarily understand them. But here's what it is, and I'm explaining this because a lot of our clients are going to watch this video if they don't fall asleep. So everything's good, and I've set up this slat, and 30 years have passed, and the assets in the slat are worth a lot more than what they were when I put them in. And now there's no more estate tax. And our descendants say, well, when Marcia passes away, are we going to get a new income tax basis? There's no estate tax anymore. They did away with that. So do we get a step up in income tax when mom, grandma, great grandma dies? And the answer is no, because she was limited in her power of appointment because we wanted to keep it out of her estate for estate tax purposes, so it was limited. Well, the independent fiduciaries named in the trust document or facilitated by appointment of the trustees could give Marcia the power to direct trust assets to creditors of her estate to get that step up in income tax basis later on. So that's why we have the independent fiduciary language for the purpose of giving that spouse that power. And when we prepare revocable trusts, my revocable trust says on my death, the trust assets are held for Marcia's health, education, and maintenance. She can direct where they go among our descendants on her death, or with the consent, if the independent fiduciaries, appointed under my trust, give Marcia the power to direct appreciated assets to creditors of her estate, then when she dies, they're going to get that step up. Those assets that she has that power over will be considered as owned by her for estate tax purposes, so the power should not exceed an amount sufficient so that her assets would not exceed what passes estate tax free. I know that probably 15 of the 170 of you here understood what I just said, but that's an important provision that should be in slats and other trust documents. Chris?
Yeah, it's great, Alan. A lot of what we're setting up here with this slat, it's an irrevocable trust, but we try to bake in as many flexibility mechanisms as we can. And this certainly is one of them. I know that recently, Alan, I actually had to use this power under a revocable trust situation where a surviving spouse had an irrevocable trust set up for her benefit, and she's got way more exemption than she needs. So we had the independent fiduciaries execute a formula to give her a general power, only to the extent that it wouldn't cause estate tax on her death.
Okay. And then you want to have the right language in there so that after the grantor's death, after I die, this trust for Marcia will be considered a separate taxable entity, but it can get a charitable income tax deduction if it gives distributions to charity, if you have the right language in the trust agreement to permit this. So that language authorizing distributions to charity needs to be explicitly in there. But then if you do that, is there a concern that the charity may take advantage of your spouse? And charities do take advantage of people. That's their job, to get as much money as they can. We just had a situation in our office where a family's very upset at how much was given to a symphony. The director of a symphony took somebody in her 80s to lunch. She was very forgetful. Next thing you know, a big check was written from a trust, and they were upset over it. So when you draft your charitable provision, have some third party approve the charitable contribution or limit it to a percentage of the value of the trust. even charities, unless you limit the names of the charities, even charities can have their own issues. So at page 100, yes, flexibility is absolutely essential. And you know, there's kind of a joke among tax lawyers and trust lawyers that the client calls and says, I need to amend that trust. And you say, you mean you want to amend the John Smith irrevocable trust? They go, yeah, I want to amend it. Okay, but did you hear me? It's the John Smith irrevocable trust. So Chris, how can you have flexibility in place? And we only have a minute here for our planned thing. So how can you explain this in a minute so that we
really quickly, easiest way, Alan, is we appoint independent trust protectors, people who aren't beneficiaries of the trust, who can modify the terms of the trust. Of course, you can't have any understanding that the grantor is the one behind it. Interpret that how you will, but the independent trust protectors can act on their own volition, as you see here in our sample language, to change the trusteeship, change withdrawal rights, change the purposes for which income or principal is distributed. And we find that to be very effective as a flexibility tool. You could go to court, or you can do a non-judicial modification in some situations, depending on the state law. But trust protectors are by far one of the more easy ways to handle this, and frankly, less costly in the future, because you don't need to go to court or decant or transfer assets to a new trust to effectuate any desired changes.
Yeah, and again, please do not use this language at home, but we are putting it together for Notre Dame, so we thought we would share it. There's you know, certainly reasons that you need to have a very careful lawyer do this. So Chris, that finishes our program time here. Do you have any final questions, any final comments before we turn this back over?
No, Alan, I think we covered a lot of it today. I would just lead by saying that the SLAT is a really effective, really flexible tool, and many clients can fit into this type of situation. If anyone has any questions, you guys know how to reach us with our emails, and please do, and we're happy that you joined us today.
Super. Thanks very much.